This is an interview with Phyllis Holmen on July 18th, 2002 in the offices of Georgia Legal Services program in conjunction with the Oral History Project on Georgia Legal Services. And Phyllis, I guess I'd like to just talk about originally the trajectory that took you to Georgia Legal Services in the first place. So what got you from where to there?
I went to law school with the idea of doing something that would enable me to participate in social change. I was in college during the anti-war years, 66 to 70, Kent State and all that, and as I say to young law graduates now, all the anti-movements, or all the movements, the women's movement, the civil rights movement, the anti-war movement, and really felt like I wanted to participate in that as a career choice. Thought about lots of different things, but my younger brother was talking about going to law school, and it occurred to me, no, it didn't occur to me to go to law school until after I graduated from college. And I started thinking about that and thought, well, maybe that was a way to get engaged in social change. So I went to law school thinking I was going to do some kind of public service law. Didn't really know much, if anything, about legal services, and worked for a legal services program in Illinois. I went to law school at the University of Illinois. Worked for a legal services program in central Illinois one summer, and really enjoyed that. And so when it came time to look for a job, I started writing to legal services programs all over the country. Never thought about coming to the South. It just really didn't occur to me. But Georgia Legal Services came to my campus to recruit. And so, of course, I and several other people, one very close friend, and then another person from my law school who was eventually hired, and three of us were hired to come to Georgia. My friends in law school were amazed. What are you going to Georgia for? You won't be able to understand them, and this and that. So, and my parents who lived in Chicago, just didn't get it at all. I had never been south of St. Louis, and I was moving to Georgia. I didn't know anything about it. But I packed up my car July of 1974 and my little red Volkswagen and drove down with a friend of mine to Atlanta to spend a month studying for the bar exam. Stayed in a room with one of the senior lawyers who was then like 3 years out of law school. Was a senior lawyer with Georgia Legal Services. Stayed there for a month, took the bar exam, and then moved to Savannah. Moved to Savannah. And I remember the day that I drove down there, and a friend of mine from law school and I were both going to Savannah. We arrived in Savannah on a Sunday, and it was dead. Everything was closed. We were just astonished, coming from Chicago where that isn't the case. We thought, oh my God, this is really dead. What have we done? But we managed to find apartments and get settled and get started. And that was the beginning, 1974. I guess I had always been, and I'm not sure where I think originally it came from sort of a faith-based kind of thing early on in my life, that I just felt that you needed to care about other people. And my mother was always very big into fairness, among us three kids. Everything had to be fair. And I guess that was just kind of the seeds of it. But I did the UNICEF trick-or-treat and that kind of stuff. And just, I don't want to overstate that, but I guess it's just always been a part of me about wanting to leave the world a better place.
Plus the larger currents of it.
And then the larger currents, right, really fed that, yeah. And I had this idea that we were going to go to work and sort of lick this poverty thing, and then I'd go on and to my next career. Very naive, but...
Well, a lot of people don't realize that the, quote, 60s didn't end in the 60s.
Right.
This very much, even though it's after Nixon's second election,
right.
And so forth, is still very much part and parcel of that.
Right. Well, I over the last 28 years now, I've learned an awful lot about society and fight for social justice and social change, and it's just very cyclical. You win some and you lose some, and it's...
Okay. Summer of 1974, maybe let's go back.
Okay. Oh, okay. Well, we moved to Savannah, and there were the Georgia Legal Services was then 3 years old, and that year doubled its funding, and had gotten a bunch of money from the state of Georgia, Lester Maddox of all people, the populist governor, and doubled their lawyer staff. The Savannah office went from 4 lawyers to 8 lawyers all of a sudden. They hired 4 of us, 2 from Illinois, 1 from Boston, and 1 local Savannah lawyer, Robbie Robinson, African-American lawyer, who several years later was killed by one of those letter bombs when the 11th Circuit judge was killed that year, and Robbie Robinson was killed by a letter bomb. He was not even really a civil rights lawyer, but opened his mail one day and was killed. That was really very devastating. Anyway, there were the 4 of us, brand new baby lawyers, moved to Savannah. Robbie was not new to Savannah, but the 3 of us were, and new to the South. And part of our charge was to go circuit riding to the counties around Savannah. That office at that time served 16 counties. We each had 2 or 3 counties assigned to us depending on how big the county was and how far it was. I had 3 counties that I served with another. We were each paired up with one of the older lawyers, or some of them were only older by a year or 2. But, we were paired up with a more experienced lawyer to go circuit riding. And we did that a couple times a month to each county. One of my counties was 2 hours away. We'd drive out 2 hours. We'd meet with clients at the welfare office. We'd go to court and handle whatever we had to handle in court. And my teammate was a lawyer named Fred Davis, who was then probably in his late 50s. And legal aid was kind of a second career for him. He'd had a practice in Savannah. I think he'd even been probate judge for a time, and decided he wanted to work for legal aid. And I think it was kind of a retirement job for him, but it was extremely eye-opening. He had no contact with low-income people before he started working with Georgia Legal Services, and I think he learned as much as the rest of us. Of course, his value to me was that he knew how to practice law and taught me a lot, as much about how to handle people, how to handle judges, and leave some doors open for judges so that they have a choice to go with you, but show them how they can go with you, and how to handle adverse parties. And so Fred and I would go out circuit riding, and his wife, Margaret, would make us sandwiches, and we'd eat. I'd drive the car because Fred didn't want to drive his car, and we'd eat our sandwiches in the car driving back from circuit riding, and it was a wonderful experience.
Which were your counties?
Bullock County, Millen, Jenkins County, and Effingham County. I remember the cities better than the counties, so it's sort of northwest of Savannah.
So as far as Statesboro,
Right, we had Statesboro. Before, the school was really big, so while it was big for that area, it was not very big.
And who'd set up like the meetings with clients? I mean, how would all that get arranged and everything when you went circuit?
I think that we changed the way that was done from time to time, but essentially people would call the office, or they would call the welfare office there in the county, and the welfare office would say, oh, the legal aid lawyer is going to be here on Thursday of next week. And so from time to time we would show up, and there would just be 20 clients waiting to see us, and we'd just take them one after another. From time to time we would have appointment kinds of situations where people would call and make an appointment. So we tried different scenarios over the years, and we're still trying different scenarios, still trying to figure out what's the best way to do that intake and initial screening.
Was there a manager of the office in Savannah at that time?
Steve Gottlieb was the manager, is now the director of Atlanta Legal Aid, and I learned a lot about being a lawyer from Steve as well. And we had, the other 2 lawyers were Bob Gill, who's now up in Boston, was from Boston, had come down in that pipeline, and Elizabeth Youngerman, who was a native Savannian, and one of the other, there were 4 women lawyers in Savannah. Elizabeth and I were 2 of the 4. One was Phyllis Kravitz, who's now 11th Circuit Court of Appeals judge, and another woman who had a basically office practice, probate and estate, I think. I never even knew her. We just knew she was out there somewhere, and I don't remember her name. So we were kind of trailblazers, and seeing a woman lawyer especially a young woman lawyer from the North who was with legal services out in those counties was an eye-opener for both judges and lawyers. And we would have experiences where, and this was in Savannah. I remember one time I went to court on some kind of consumer case, and I put my papers out on the table, and I took out a couple of law books with statutes in them, and the lawyer on the other side, it was like a collection case on a washing machine or something like that, and the lawyer on the other side looked up at the judge and said, "Judge, this isn't fair. She's got law books with her." But it was we knew that we had to be prepared and we had to be better because we were starting from not a level playing field, let me put it that way. Although we often had the facts and the law with us. We had to convince the judges and we had to show the lawyers.
What kind of other sort of reactions, specifically to young women, Yankee women doing legal services?
There was one lawyer there. We did a lot of collection stuff back in those days, a lot of consumer cases. Steve was real interested in consumer work, and it was kind of a ripe area then. The law was actually, probably through negligence as much as anything, fairly pro-consumer. So we did a lot of stuff with small loan collections and furniture repossessions and things like that. And there was one lawyer in particular that we dealt with a lot. He represented a bunch of collection agencies, and I remember one day being in court with him, and he made some remark about, glancing at me, habeas corpus, and I said, "What are you talking about?" And he said, "I'd like to have that body." There's not much you can say to a remark like that, but, and I was then maybe, 29, 28, something like that, but sort of walk away and shrug.
I'm trying to get something of just kind of the early years and sort of the spirit of early Georgia legal services, sort of this, this sort of atmosphere, the sense of mission, nature of the office.
Yeah, the program was really great because it put a big premium on training, and it brought lawyers together. I remember not long after I started, we had a new lawyer training, and there must have been 20 or 25 of us. It was a huge class of new lawyers. We all were brought into Atlanta for like a 3-day training, and we still do this for new lawyers every year. And we had 3 or 4 days of relentless lectures from what we call then and still call the specialist attorneys. There was a consumer law specialist, a housing law specialist, welfare law, and Georgia procedure. And so we got lecture after lecture after lecture, public benefits, food stamps, and so forth, which to most of us who hadn't gone to school in Georgia, and no law school really taught poverty law then, was all new stuff. So we were frantically taking notes for day after day after day. We thought we'd finished that stuff, but we really wanted to know it because we needed to know it to represent our clients. But we also developed a real camaraderie among the group of the new lawyers. Then later that fall, we had a training on family law, which was a big part of the practice then as now, up at Unicoi. And we had a terrific time up there. You can imagine it was a sort of parties every night at Unicoi and hiking in the woods. And we were just all thrilled to get exposed to North Georgia and be back together and get to know each other. And so Georgia Legal Services really did a lot to foster that kind of collegiality and team building, and also wanted to make resources available to us out in the field. These specialist attorneys we could call anytime. Now in Savannah we had the more experienced lawyers, and Steve Gottlieb in particular had this philosophy that we were going to figure it out in Savannah. We weren't going to call those people in Atlanta unless we absolutely had to. And I think that tension between the field offices and the Atlanta offices persists to some extent. It's kind of like, the home office and the field offices. Well, we can figure it out how to do it ourselves. but we struggle with that
What
a
would be
little
the
bit.
sort of the chain of command back then, or the nature of the communication back and forth?
Well, when I was a staff attorney, I mean, I wasn't really in on much of the chain of command with vis-a-vis Atlanta, and I'm sure Steve had talks with then John Cromarty or his predecessor, Greg Blair, in Atlanta, and I don't know what those conversations were all about, except for the lawsuit, which I'm sure we'll talk about. We did talk with the so-called specialists on various cases, but mostly we did just figure it out ourselves.
And you would take pretty much as a staff attorney a general caseload?
Yeah, almost anything that walked in the door. We never heard of anything like priorities or case acceptance criteria like we do now. It's pretty much, and we had huge caseloads. We had caseloads of 120, 130 cases. And
So you were handling 100?
yeah, I mean, not all of them were, in court, not all of them were active at any given time, but we had open caseloads of 120 cases. And looking back on that, I mean, we would never let that happen now. So standards of practice hopefully have improved some since then.
Well, Greg Blair was the head for a while.
Right.
And maybe talk about him and his style and approach and so forth.
I believe that he was director when I was hired, although I had more to do with John Cromarty, who was then director of litigation. I only crossed paths with Greg probably once or twice. And it was only later that I learned about the struggles between him and the state bar, basically. He just had a whole different Yankee kind of style that didn't really fly with the state bar here. And I think he was just a little bit more aggressive. He had a philosophy about legal services that I think most of us agreed with. That is, that the mission was about social change, and that you had to take your battles as you found them and fight them as hard as you could. But I think he didn't do it in the way that Southerners do it, and and not being born and bred a Southerner myself, it's hard to explain that, but having been down here a while, I can sort of see how that would grate on people. Beyond that, I can't say too much about Greg, because John became director.
75, I think.
Yeah, right, and I started in '74, so it was just a year
Maybe
later.
talk about John's style, philosophy, way of doing things, vision.
John had a real charisma, and he charmed everybody, and he was a terrific leader in that way, because everybody just wanted to be around him and with him and working on things he was working on, and he had a way of articulating a vision about change and about the mission of legal services that was powerful in rallying the troops, but also I think compelling to people who would be inclined to be a little threatened by it. I mean, he sort of knew how to talk about right and wrong and moral values, and he was funny, and he was real positive and encouraging, and when I became managing attorney in Savannah, which was my third year out of law school, I remember having to call him up and talk to him about stuff, and he had a way of just not talking. And you talk to him, you'd ask him a question or you tell him something, and he just wouldn't say anything. And he actually would make me a little uncomfortable. I wasn't sure whether I was doing the right thing or not, but I think he was just trying to draw you out and, in a sense, build your own confidence and build your sense that you could handle it yourself. But sometimes it was annoying that he wasn't helping more.
He was funny?
He was funny. Oh yeah, he was real funny. I mean, I can't give you a specific example, but he could always kind of lighten he could be light when you needed to be light. He could be serious when you really needed to get people moving, and he just had a really good sense of values about what the program ought to be about, client-focused, and working for the clients. He also had a real strong commitment to a couple of things. One is hiring paralegals out of the community, because he felt that they would be best able to relate to the community and understand the community needs, and help the legal services offices help the community relate to the legal services offices. And I think that was real important. And it was also important to give community people good jobs and to teach them how to be advocates for their communities. And the other thing that he really focused on was opportunities for African American lawyers, and women too, I think, because women in rural Georgia were pretty uncommon back then. He really believed that for African American lawyers, legal services was a prime, and in some places the only, job opportunities. And so he was real intent on finding good African American lawyers and hiring them and supporting them. And a number of those lawyers have gone on to become judges around Georgia, run for public office, become real successful. The Chief Justice Benham worked for Atlanta Legal Aid for a number of years, but for not a number of years, a brief period, but it was a real way that doors were open for people. And I mean, and the flip side of that is that the fact that those people ultimately were tapped for those kinds of positions kind of legitimized legal services as a career path, as a legitimate part of the profession, that you could become a good lawyer, and there were good lawyers with legal services.
Did you feel that you weren't quite seen as legitimate members of the profession, say 1974, 75, 76?
I think there was a part of that, and I think some of us, and maybe particularly those of us who are not from Georgia, didn't feel really like a part of the community. I can really only speak for Savannah, and I mean lots of newcomers to Savannah then anyway talk about how hard it was to get established in the old Savannah community. We weren't really interested in getting to become a part of the establishment in Savannah, and there was a progressive community, a food bank, and the Whole Foods store and that sort of thing that we did run with. But I think there was a bit of a struggle to get us to go to bar meetings. Of course, the Savannah bar back then was not exactly hospitable to legal services. On the rare occasions then that we did go to the local bar meetings, it was not a pleasant experience. You know, we weren't welcomed with open arms. People didn't come over to talk with us, and pretty much sat by ourselves. That was probably a two-edged. There was probably a little fault on both sides. I mean, we kind of held ourselves apart, I think. So felt, you know, and maybe there was a little bit of that mission-driven kind of. We've got to keep ourselves pure and not mingle with the establishment, because Lord knows we might get corrupted by that. You know, I think it's a pretty naive and not useful view.
Let's maybe move from there to this case in Savannah, where
right.
Legal Services was sued, correct?
Right. That case was filed in December of 1974. And it named Steve Gottlieb and Rob Remar, two of the lawyers in the office, as well as Georgia Legal Services, Inc., the corporation. And the charges were that we were engaged in what was framed in the complaint as champerty and maintenance, which is essentially ethical violations about supporting clients to bring lawsuits, paying the court fees and so on and so forth, even paying the clients, none of which we did. And there was a claim that we were a corporation practicing law, which was unlawful except if you were a nonprofit corporation, or unethical.
So explain this a little bit more clearly to the layperson here.
About the corporation practicing law? The ethical rules said that lawyers had to practice law. People, human being lawyers, had to practice law. Corporations could not practice law. And but there was an exception for nonprofit corporations, and I think the idea was that maybe it was a change in the law to permit an organization like Atlanta Legal Aid or Georgia Legal Services as a nonprofit corporation to deliver legal services. And that was ultimately our defense on that count, that there was an exception in the ethical rules and there was no basis for the lawsuit. when the lawsuit was filed, a Superior Court judge in Savannah entered a temporary restraining order prohibiting Steve Gottlieb and Rob Remar from practicing law individually and personally. That the people from Atlanta started coming down, John Cromarty and Bill Ide, and people who I didn't know and didn't get really chummy with because I was just a lowly staff attorney 6 months out of law school. But we were all caught up in this, and I remember spending time in the library trying to do some research, trying to figure out what the approach could be on this lawsuit. David Webster was another one who came down from Atlanta Legal Aid, and they got Sonny Seiler, a local Savannah lawyer, to handle the case for us. And we found some law that said you couldn't sue federal officers in state court, and or officers of a federal instrumentality or something like that. And so we filed a petition to remove, the lawyers filed a petition to remove the case from state court to federal court, thinking that federal court would be a more hospitable environment, which was tended to be the case down there in the South. We succeeded in getting it removed. They then changed that law as it applied to employees of legal services programs. We were federally funded through OEO at the time, and that was the argument about why we were federal officers of a federal instrumentality, that we had this federal funding. So we were moved to federal court, and Judge Lawrence ultimately dismissed the case. It was appealed to the Fifth Circuit, and ultimately lost in the Fifth Circuit, which the court said that the remedy for the plaintiff was to either pursue ethical complaints to the Bar Association or his grievance with the OEO at the time, but not in court. He didn't have a claim to go to court.
And since you had a relationship with the Bar Association, an ethics complaint probably wasn't going to go too far, is that?
I think it wouldn't have gone too far, just because I don't think there was any merit to it anyway. But that never happened. The whole thing stemmed out of a dispute between a former mother-in-law and daughter-in-law involving there had been a divorce between the daughter-in-law and the son. The daughter-in-law was awarded some of the property in the divorce that the mother-in-law had possession of. So we filed what was called a trover action to get, it was like a couple of candlesticks in a vase or something like that. Nowadays we wouldn't handle a case like that, but we filed this case against the mother-in-law to get that property. I guess it had some special value to our client, and the lawyer who represented the mother-in-law thought that, just had a philosophical objection to legal services and seized upon this case to file his own case on behalf of his client, saying we shouldn't be permitted to bring this kind of lawsuit and we must be supporting the daughter-in-law in bringing this lawsuit against his client, the mother-in-law.
Okay.
Did I lose you there?
What authority did legal services have, to represent the daughter-in-law in a domestic kind of situation like this?
Our charge was to represent low-income people in civil cases, and this was our client qualified financially, and she wanted her property back. So. And
the particular, this is Joe Bergen we're talking
about? Right.
His argument was what now?
Well, I think fundamentally he didn't like federally funded lawyers. Didn't think that the government had any business providing lawyers to poor people. But his legal claims were, as I said, these technical claims of champerty and maintenance, which essentially mean the lawyer has got to be financially supporting the client because the client wouldn't have any way to bring this lawsuit by herself. You're paying fees. Sometimes it applies if a lawyer is paying, say, living expenses for a client, and we never did that. But that you're not supposed to enable a client to bring a lawsuit by financially supporting a client. We never did that. We weren't doing that then. But that was his claim. I guess he thought.
Although certainly she wouldn't have been filing I'm going to play devil's advocate.
Yeah.
She wouldn't have filed the suit
without a free lawyer.
Without a free lawyer.
Right. But there's nothing unethical about that. If we were to have been paying her rent or buying her food, that's what the ethical rule really goes to.
But then it went to this larger question about whether a corporation could practice law.
Right.
And whether you were a corporation.
Right. And there was an exception for a nonprofit corporation engaged in the provision of legal services for low-income people. I mean, the idea is that, the Bell Telephone shouldn't be out bringing lawsuits and signing Bell Telephone as the lawyer. But that's not what we did. We never signed Georgia Legal Services on the pleadings of anything we filed. We always signed our own personal names as lawyers. So how serious was this? Well, it was very scary at the time, and it took a lot of energy. I think it was very serious because, first of all, he convinced a judge to enter a temporary restraining order, Superior Court judge, and that was scary. So it was very important that it be well defended and that it fail, because if it had succeeded, I think, there would have been no legal services. So it was very serious.
What role did the State Bar play in all of this at that point? I think Cubby Snow was the State Bar president.
I couldn't tell you.
Because there had been a relationship with the Bar Association.
Right, and the Younger Lawyers Division and the founding of Georgia Legal Services. I knew there were lawyers from Atlanta who came down and, did a lot of the stuff in terms of lining up resources and strategizing about how to handle it. And we staff attorneys were detailed to do some of the research and so forth. But I couldn't tell you what role, if any, the State Bar had. I think there are other people who probably could.
And your strategy was first to get it transferred.
Right, to federal court.
And the other dimensions of the strategy were to say that there was this exemption for this particular...
Right, to say that his claims had no merit, and the federal judge ultimately dismissed his case. And then he appealed it. Joe Bergen appealed it to the Fifth Circuit, and he lost there as well. It's a reported decision. Dixon versus Georgia Indigent Legal Services. So, but we won. That was the main thing.
Big challenge.
It was a big challenge, and it was scary that soon out of law school, but it was also, kind of contributed to the sort of us-them mentality, and that we were sort of under siege, and, in times of adversity, it kind of rallied the troops.
Meanwhile, there's also stuff happening in the state legislature right around the same time.
Yeah, Georgia Legal Services had been filing lawsuits, filed lawsuits against small loan companies, filed lawsuits or defended lawsuits by small loan companies, filed lawsuits involving housing authorities, involving furniture companies, had sued the state on Medicaid issues and other issues, and so there was a lot of impetus in the legislature, people calling their legislators about what is this state money going to support these lawyers who are suing us or preventing us from collecting our bills and this and that. And so the state money that had been appropriated that enabled the program to double in size in 1974 when I was hired came under attack and was cut off. The timing of that is a little unclear to me, but it was probably cut off in 75 or 76. Perhaps effective, fiscal year, July 1, 75, something like that.
Yeah, that sounds right.
And, when I read about that time now, I read about how top management, John Cromarty and others, were preparing for the demise of the program and were scrambling to muster support to get funding from other sources. That was not really apparent to us at the lowly level of staff attorney. We were just doing our cases and circuit riding. I don't even remember being told to cut back on caseloads, although I suspect that we probably were taken off intake for some period of time. But I do know that then there was a big effort after the formation of the Legal Services Corporation by federal statute in 1974 to get the Legal Services Corporation to pick up that lost funding for Georgia Legal Services to enable the program to continue. And the issue about that was the federal agency was reluctant to pick up funding because they felt that they might have to then do it in every state. That every state that provided state funding might decide, well, we don't have to do this, the feds are going to do it. So there was some tension about whether they were going to come to our rescue. Ultimately, they did. I think we probably got funding for them in '76. And so we survived that crisis.
But you're saying the ground level lawyers really weren't.
Well, I wasn't. Others may have been. I was just handling my 120 cases, trying to get out to my counties on a monthly basis.
Didn't the establishment of Legal Services Corporation add additional restrictions as to what lawyers could or could not do? Is that correct in terms of community organizing? Or?
It did. As to what was in the original act in '74, I'm not sure what the details of that were. It didn't affect us on a daily basis then. I mean, I was fortunate enough to get involved in some appellate work early on and some federal cases fairly early on, and had a lot of fun doing that stuff. I mean, that was part of the reason, we wanted to change the law. That was part of the reason we were there. So I don't remember impact of the restrictions. Fairly early on, I think there were those organizing kinds of restrictions, because in the OEO days there was this whole idea of community lawyering and being out there and organizing people and community groups, and we were subsequently restricted from doing that. We did get engaged in a lot of, Georgia Legal Services was heavily involved in prison litigation and did some nationally precedential work at Reedsville, transformed that facility. We did some early work on voting rights, Southern voting rights issues, and all that stuff, of course, was subsequently restricted as well. As you have an impact, as you gain success, they realize they better restrict you from doing those kinds of things.
Either of those areas, prisons?
No, I wasn't.
So which are the federal kinds of cases or appellate cases that you were involved in? You said you had fun.
Yeah, I did some appellate work on procedural technical issues, but issues that were important as far as clients getting access to court. I got involved in some consumer work. Later, I got involved in some mental health work and continued some consumer work. Some public benefits. I did a class action on vocational rehabilitation that established hearing rights for clients. I did much later did a case that was involving father's custodial rights when the child had been taken away, or his rights had been terminated sort of by deception. I can't even think of them all. Social Security appeals, a lot of the mental health stuff I got involved in.
Any cases stick out?
I mean, the mental health cases were real important to me because they were clients who were not real popular, even among legal services clients. I mean, there were people who were interested in certain areas, like the prison work. I never really was interested in prison work. But the mental health clients I was interested in, and at the same time there were other colleagues of mine who really didn't care, not that they didn't care about the clients, but didn't have the interest in learning how to relate to clients with mental disabilities. But I had done some work, some psych courses in college, and so fancied myself as having an interest in that area. And we did some cases class actions and appellate work and regulatory work involving release procedures for people who had been institutionalized for years and years, for children who had been institutionalized and abandoned in state facilities, Parham versus JL and JR. You probably have heard of that case. I was real involved in the remand of that case from the Supreme Court in terms of developing and implementing the regulations about the hearings that the children were entitled to, and we got lots and lots of kids out of institutions. SH and PF versus Ledbetter involved developmentally disabled adults, some of whom had also been abandoned in facilities for the developmentally disabled with no hearing rights. And so we got hearing rights established for them. We got lots of those folks out. And some of those people became real personally important to me. And their success, although some didn't have success living in the community, so there would be struggles over that. So that work was really important because I think that's a real vulnerable population, and that work's still real important for me.
What was the response of either Parham or Ledbetter, throughout all of this?
Jim Parham, while I didn't know him personally, by reputation was a really wonderful man, and actually in some respects wanted to be sued over these issues. And I mean, some people in the establishment understood that lawsuits were the only way that they were going to be able to bring their institution into the modern era, whether it was a jail situation. Some sheriffs were not averse to being sued. Not that they were collusive lawsuits, but they understood that that was the only way that there was going to be any change. And not that Jim Parham colluded in lawsuits, but he understood that it was the only way that he was going to be able to make some changes that he wanted to make. Jim Ledbetter was not quite so open-minded, but it was not a situation where the department was openly hostile. We would have our issues with the Attorney General's office, but that you just have issues like that with any lawyer on the other side. With
Arthur Bolton, is that it?
Arthur Bolton, he was really good in the Attorney General's office. But there were.
Or is this into the Bauer? There's still the Arthur Bolton years, isn't it?
Early on, yeah. But we mostly didn't deal with the Attorney General. It was other people, and you just have the trials and tribulations of litigation.
They're representing the state.
They're representing the state, right? We're suing the state. Right.
We're rolling. If you want to try and trigger that, just the end of that sentence would be.
Okay. Well, we were saying, you sometimes got into stuff with some of the staff in the Attorney General's office around some of these.
Well, they were representing their client, and of course we thought, like lawyers do, they were being unreasonable. I'm sure they thought we were being unreasonable, but we worked out a lot of problems. A lot of cases were settled without, major trials, and I think that was an era that I think has an impact to this day in the sense that we established a reputation of being willing to go to court and doing the hard work and challenging government agencies, challenging authority when we felt they were implementing programs incorrectly or unconstitutionally. And I think that today that reputation helps us in working with the people who are in charge of these agencies now, and, without having to litigate issues. We can call them up and we can say, you got an issue here, let's sit down and talk about how this program is being run and whether we can come to some accommodation about how we think it ought to be run versus how you think it ought to be run and what resources are there for the program and so forth.
Can you give, for instance, perhaps?
Well, we've, the whole period of TANF implementation, welfare reform that came on in the Clinton years, our lawyers who specialize in welfare have been able to work closely with the people at the Department of Human Resources on straightening out some of the issues that that came up in terms of certain kinds of waivers, domestic violence waivers, working on reasonableness of work search requirements for people with disabilities, and we've tussled over some of those. Some of those have been easier to resolve than others. Medicaid is another area where we've been able to work with the leadership of that agency because of the reputation that we established early on with the litigation, that they'd rather sit down and talk to us about the issues than go through that again. So now the problem with that is that our younger lawyers don't necessarily have the opportunity to learn to litigate those kinds of issues in the ways that we did early on. But ultimately for the clients, it's better to resolve things as efficiently as you can.
Without these class actions.
Right.
It's interesting. Was there a tension between these larger cases and kind of just the everyday caseload? I mean, part of your mission is to service poor people.
Right.
And then there's also this desire to kind of take on these larger questions and issues.
Right. There was, and there are some people who just felt that the work for individual clients really ought to take priority, and there were others, and I was always in the camp that it was more interesting, on the one hand, to do the more challenging kind of complex cases, but also you could achieve more for clients. We had a situation with a housing authority in one of the counties that we served. This was after I was over in Douglasville. And the housing authority director ran the housing authority as if it was his plantation. He would insult his tenants, he would, use racial slurs and all kinds of just insulting to clients. Your children need to get out and get jobs and that sort of thing, and worse. And had no regard for any kind of rights to hearings that were guaranteed by federal laws and regulations, intimidated the clients. And so we worked very hard to try to find a way to move that guy along into another line of work. And ultimately, but the clients, the residents of the housing authority were so intimidated that they were real scared about standing up and doing anything. We finally ran into a couple of clients who just were willing to put it on the line, and we filed a lawsuit in federal court against him. But there was the tension between representing the individual clients and their eviction actions versus the time and energy that it took to file a class action, and no guarantee of winning, and the trouble that, we were afraid to go into that county after dark.
Which county was this one?
I probably shouldn't say. That's years and years ago, but I don't want anybody to take any personal offense. And that housing authority director did move on to another line of work, and the housing authority there got much better. But I still feel to this day that resources are scarce, and you really can be more effective, or need to at least consider whether you can be more effective in targeting certain kinds of issues, rather than just taking the next 10 clients who walk in the door, because there's 10 more behind them and 100 more behind them, and that's important to solve those individual clients' problems, and that's how you understand what's going on in the community and what's important in the community. And you can make an impact on the system that way. We have, in the last 5 years or so, made a tremendous impact in Columbus in the whole way domestic violence victims are handled, just by handling cases and coming before judges and talking about these claims with lawyers on the other side, and the domestic violence task force and law enforcement. Just being there representing individual clients, we have made a tremendous impact on how the system responds to those clients. So you can have an impact, and that is important. But I think the idea is to be strategic in how you pick your issues and how you use your resources, because we're never going to have enough to represent every person who needs a lawyer.
At different points during the history of legal services, how would these kinds of things be thrashed out?
Well, we would talk about them at managers' meetings, and people would have different perspectives. John was always supportive of doing major work, but he was also very insistent that you know what you're doing. I remember he always would say, if you can't convince me about your claim, how do you think you're going to convince a judge? So you knew you had to get your act together, and you knew you had to have your facts and your law and know what you're doing before you embark on something.
And would you have to clear it up the line?
We always had policies about getting approval for appellate work or federal work, class actions. There was always a litigation director you had to work through. There were these specialist attorneys who were real resources and real important for that work.
Let's move back to the late 70s, which is, as you said, a period of growth.
Right.
Carter years.
The golden years.
The golden years, okay.
We had two golden years later, right after Clinton got elected, but Carter was the Carter term was really the golden years.
Well, let's talk about the golden
Yeah,
years and
yeah.
some of the issues attendant to the golden years.
Yeah.
That, you have infusion money, tremendous expansion of
Right.
offices, and with that comes some
Right.
new challenges, new issues,
Right,
etc.
right. 76, Carter was elected. And it took a couple years, but Hillary Clinton became president of the Legal Services Corporation. Hillary Rodham then. And tremendous new money. When I started with Georgia Legal Services in 1974, we had 9 offices around the state. By 1978, we had 21 offices. Some of them were small, 1 or 2 lawyers, and there was always a debate about, what's the minimum size that an office should be, and people had different opinions about that. Some people felt just having an office in a community, regardless of its size, was an important deterrent to the bad actors. But the other side of that was, how effective could those people be if they didn't have colleagues to bounce ideas off of, resources at their hands, that sort of thing. But we went through a huge expansion, as you can imagine. We hired lots of lawyers. We did lots of training, lots of recruitment trips. I mean, it was really a wonderful period of time trying to figure out where to open offices. And I had left Georgia Legal Services in the summer of '77. Worked in Savannah from '74 to '77, went back to Chicago for a year, worked for legal services up there, couldn't stand the weather, and John Cromarty offered me a position as a managing attorney in the Douglasville office, so I came back in the fall of '78. And that was when, I remember when I was leaving in '77, they hired a big new class of people, and in '78 it was another big new class of people. And so, as I said, lots of training, new offices were being opened. I think the Douglasville office was a new one. It wasn't brand new for me, but it had been recent. There was an office on the other side of Atlanta in Conyers that was relatively new. There were just, new offices everywhere. We had statewide staff meetings that were huge. We had 300 people working for the program at the time. And we had double the specialist staff. They were all over the place. It was just really a great period of time. And from the national level, there was a lot of training going on, lots of new initiatives. I remember I got tapped for a program where they trained legal services staff. Now, mind you, I'd been around 5 years. They trained us to be consultants to other programs who were having sort of growing pains issues. So I went through a 2 or 3 day training, and then they would send me to other legal services programs for me to tell them what to do 5 years out of law school. It was an amazing time when there were just lots and lots of opportunities, and it was really great. I can't remember. Well, we were filing lawsuits. That was the time when I did the vocational rehabilitation lawsuit, when we did this housing authority lawsuit. Then, of course, 1980, Ronald Reagan was elected. Yeah. The bottom fell out. His very first budget, which would have been spring of '81, no money for the Legal Services Corporation, 0. David Stockman, Ed Meese. Ed Meese and Ronald Reagan had intimate experiences with legal services in California, which sued them over Medicaid, which created problems with farm workers. And so their mission was to eliminate legal services. And 7 of Reagan's 8 years, his budget contained no money for the Legal Services Corporation. The American Bar Association got real involved. The ABA had always been involved in supporting legal services way back to the 20s.
Right. Certainly since the 60s with Lewis Powell.
Right. So they got very, very much involved in rallying Congress and building a bipartisan coalition to support legal services. We took a cut that first year. I guess it hit in '82, lost 25% of our funding. And I remember we had a big staff meeting in Atlanta. I guess it was sometime in '81 or maybe '82, where we talked about retrenchment and what we were going to do. And there were hiring freezes, and we formed. John Cromarty and the real leadership of the program. I was managing attorney then, but not closely involved with that. John formed a reduction in force committee, which was a huge committee to develop a policy about how we were going to implement a reduction in force in a fair way. There was a huge affirmative action committee to figure out how we were going to implement reduction in force in a way that preserved the affirmative action goals. There was then an organization formed called the Organization of Black Employees that was, as it says, an organization of the black employees who were real worried about how this was going to affect them. I don't think they had to worry about John's views on the matter, but they wanted to make sure their views were heard. And it was a time of a lot of tension. We spent an awful lot of energy trying to figure out how we were going to scale back. The Legal Services Corporation board was packed with people who opposed legal services. The national board is 11 members. It's a bipartisan board, 6 of whom are the party of the administration and 5 of the other party. But so the 6 are always packed with whatever the philosophy of the president is. And they were packed with people who wanted to eliminate legal services, who hired people to staff the Legal Services Corporation who wanted to eliminate legal services. And so they set about conducting monitoring visits that were pure harassment. They created all kinds of record-keeping procedures and requirements and reporting procedures that just were unbelievably burdensome. We got to where we had to send everything to the Legal Services Corporation in Washington by certified mail, so we would get a receipt that they got it. And it was just a time of terrible hostility and increasing restrictions, as we talked about earlier. Restrictions on legislative advocacy started then. I think the restrictions on voting rights started then. I'd have to go back and look at the timing of all that, but those were bad years. But we continued to try to do what we could. We were closing offices, so we went from 21 offices down to 18 and 16, and now we're at 12. But we've been lower than that since those years.
Where did you get funding from then? Funding strategies.
Well, IOLTA got started in the 80s, the interest on lawyer trust accounts, and we got, John was very active with the state bar and really cranked up the support of the state bar, went to some of the state political leadership to help us with Washington. It was pretty much felt that we were not going to be able to get, I don't know if there were any efforts to get state funding then, but if there were, they were not successful. But we thought that there were at least some political leaders who would support us in Washington and with the Georgia congressional delegation, and so they did some of that. John, of course, was always cultivating state bar leadership and younger lawyer leadership to continue to support legal services. That was real important. So IOLTA got going. We got our bar campaign going during the 80s. We hired Tina Bledsoe, our first sort of public relations, congressional affairs, to look after that sort of thing and begin a real serious development fundraising kind of effort through the bar campaign. The first year we raised $30,000. It was a small start, but that's become real important.
Let's talk both about the bar campaign and IOLTA and sort of what they were, how they evolved, how they developed, etc.
And again, there are people who could tell you more personal details of all that stuff. But IOLTA began as a voluntary program. It's I think others have described it to you, but it's a program that requires lawyers to deposit escrow accounts and interest-bearing accounts, where the interest, client funds into interest-bearing accounts, and the interest is then turned over to the Georgia Bar Foundation, which in turn distributes that money to the Georgia Indigent Defense Council, legal services programs, and other law-related kinds of programs. It started as a voluntary program, and IOLTA programs were getting started around the country, usually starting as voluntary programs and then moving into mandatory programs, which of course produced a lot more money. A few years, Jim Elliott was real instrumental in convincing the Supreme Court to establish that program. It was
The Georgia Supreme Court.
the Georgia Supreme Court. It was established by rule.
I mean, the Georgia Supreme Court has the authority to institute something like that?
They did. Then a few years later, they made it mandatory, I guess on a showing that it would be much more productive. Now, of course, the program is under constitutional attack. That's going to be decided by the United States Supreme Court, so we're holding our breath on that one. It's become a real important source of funding for us. We get over $1 million a year. You know, it's about 10% of our funding.
This idea surface, I mean, it's just an interesting idea, you know.
You know, I don't know who had the idea first, but I can tell you now, even today, we sit around in conference rooms and brainstorm about ideas of how to get more money. And I was at a meeting like that yesterday, and so I assume it was just some lawyers sitting around in a room saying, well, look at this, here's this money, this could be used in a better way. It was an extremely creative idea. The bar campaign was started about 85, 86, I believe, something like that. And I think there were some efforts to do the same thing in other states, although we were pretty much in the early pack on that. Atlanta Legal Aid was getting started with its bar campaign directed at the lawyers in Atlanta, and we got together with them and sort of struck a deal. Some members of our respective boards struck a deal where Atlanta Legal Aid would focus its efforts on the big Atlanta law firms, and we would focus our efforts on the lawyers throughout Georgia and include a solicitation for Georgia Legal Services on the bar dues notice, which has become very important, a very cost-effective way for us to raise money from lawyers throughout the state. And the Georgia campaign is among the most successful in the country that are statewide. The Atlanta Legal Aid campaign, by focusing on the big law firms, gets a lot of bang for the buck. Ours is much more of a direct mail, personal, individual lawyer kind of appeal, where the individual lawyer has to get out his or her checkbook and write a check or attach a specific amount to their dues contribution. So it's a real personal statement on the part of lawyers. About 2,400 lawyers, about a little under 10% of the total membership write checks to Georgia Legal Services, which is a political statement as much as a financial statement. And it is technically sponsored by the state bar, which is also an important political engagement. Our fundraising director and I meet with our bar leadership each year to talk about the campaign and their goals about the campaign and how they want to do the campaign, although we do all the work. So it's a real important way to keep the state bar engaged.
So the development of IOLTA, the development of the bar campaign,
Right.
you know, at least in part, offset some of the cuts of the
Right.
cutbacks in legal
Right.
services
Right.
corporation.
And it became more and more important to diversify funding, as with all nonprofits. So we began to look at other sources of funding, like government grants and contracts, and we began to get funding under the Older Americans Act, which had a specific portion to provide legal services to senior citizens. And we get significant funding from that source now. And as the federal government developed programs to serve other kinds of populations, like persons with AIDS, like homeless persons, persons with mental disabilities, we would do what we could to tap into the advocacy angle of those kinds of programs. And even now, it's a constant search for more programs where we can write grant applications or contract with government sources.
Linda Klein, who?
Linda Klein was president of the State Bar in '95, I
Okay,
believe.
so this is the more recent.
More recent, and post the Republican Revolution in '94, which resulted in a 30% cut in funding for the Legal Services Corporation and another plan to zero out funding for legal services. Linda became concerned after that major 30% funding cut and decided it was time to go back to the Georgia General Assembly for state funding to replace some of that funding. The bar legislative folks were pretty skeptical that anything could be accomplished, but Linda Klein is very effective at what she decides she wants to do. She came to the State Bar's Access to Justice Committee, on which I served, and Steve Gottlieb was a member, and a number of other, legal services supporters were members, and said, what do you think is your greatest need? What kinds of issues do you think we could get funding for? And we hit upon the idea of domestic violence, which was, very hot issue at the time, very much of concern then with Attorney General Thurber Baker, Chief Justice Benham, and we felt like we could muster some support for funding for those victims. And she said, all right, we're going to do this. And she led the State Bar in an effort that resulted in a $2 million appropriation the first year she undertook this. And the bar lobbyist didn't think it could be done, didn't think we'd even get a penny the first year, thought it would take some time to get an appropriation. And Linda, through work throughout the state with local bar associations, calling up their local legislators saying we need help for victims of domestic violence, getting local bar associations engaged with their local domestic violence shelters, so that they could understand the need. She went out and talked to editorial boards of papers around the state. She led a phenomenal campaign that resulted in a $2 million appropriation of state funding.
Where did the governor come in on all this?
Well, the speaker is not a big fan of legal services. As much of a populist as he is, he's not a big fan of legal services. And so I think they kind of did it around him. The governor then would have been...
Just because it cuts into the work of defense lawyers, he's a defense lawyer, or...
I'm not sure. I think it's a complicated history with constituents perhaps running in with legal services lawyers. We've just always been told not to confront the speaker, just don't get in his face and leave that alone. So I'm not sure what the history...
This is 95, it would have been Governor Miller.
Right.
It is 95.
Right, that sounds right.
Still been Miller.
Who was himself a populist, and I think that he was with it. The Chief Justice was extremely supportive, and I think out of respect for Linda and what she was trying to do, people got on the bandwagon. She got the Attorney General to support it, and other key people in the legislature.
Now, you came on in 90, correct, as the executive
Right.
director. Why did John Cromartie leave, first of all?
He had been going to school part-time for the preceding decade to be ordained as a Methodist minister, and he finally achieved that goal. and decided that was where his next career path was going to take him. And so some people approached me about applying for that position. I was litigation director and having a great time as litigation director, and I had to be convinced to apply, but I did, and I'm not sure I considered myself lucky at the time, but was chosen for the job. And it's really on-the-job training. It's kind of an entry-level job in a sense. Learned a lot on the fly. John was helpful, but I think he had the idea that once you're out of there, you should be out of there, and you should let the new person do what the new person wants to do. And I think that was very wise on his part.
What did the new person want to do?
Well, that the old executive director shouldn't be interfering with the new executive
What
director.
did you want to do?
I felt like I had a lot to learn about how to run an organization that big. I didn't really come in with an agenda because I thought that the organization was doing good work. I thought that we really just needed to continue to do the good work that we were doing. In '92, of course, Clinton was elected, and we thought the golden years had returned. So we, we're preparing for lots of new money and looking at loosening up restrictions, but the people with the Legal Services Corporation were kind of slow in getting all that in place. And of course, in '94, we had the Republican Revolution in Congress, and in '95 had an additional cutback in funding. In '96 had a 30% cutback in funding. So the golden years in the early '90s didn't last too long, and it, quickly became engaged in just preservation of the organization. It was originally, I didn't have an agenda to change a lot of things. I had an agenda to keep doing what we were doing because I thought it was good. I mean, growth, of course, new funding, of course. Try to figure out
major cases.
Right. Try to figure out how you run an organization like that. I did have a goal of getting over $10 million in funding. I think we were about 7.5 at the time. I had no clear idea how I was going to do that, but that was a goal that I wanted to achieve, and we did get there. Probably 96, 97, something along in there.
After this, going back to the legislature?
Right. That was significant.
When you said you had to learn a lot on the fly, what are you referring to?
I had to learn how to deal with our union. I had to learn how to deal with, understanding more about the finances of the organization. I had to learn more about personnel issues. I had to learn more about dealing with a board. I had to learn about dealing with a board and understanding what the board, how to relate to a board, how to use a board. During my job interview, I was told that I would be expected to get more engaged with the state bar. I said I had no problem with that, going to Board of Governors meetings and so forth. And a couple years after I was selected, I was persuaded to run for the Board of Governors, and was elected in 1992, and so have become much more involved with the state bar, and I think it's been real important for legal services to be visible. And I've been on the executive committee of the Board of Governors for 4 years. I've just been elected for another 2-year term, which is even more visibility, and I think that's been real important. It's just been getting an understanding of how you steer the ship, and then how you become a leader, and how you exhort people to continue to do the kinds of work strategically, using resources and so forth, when we're struggling with all these restrictions, and we're struggling with funding struggles every year, and new reporting requirements from funders. It's become more and more of a management challenge and an administrative challenge on a daily basis for the local managers. It's not just we hand you the money and you go out and do cases. We hand you some money, but you have to do certain kinds of cases, and you have to keep certain kinds of records to make sure you're doing the right kinds of cases, and you have to fill out certain kinds of reports at certain kinds of intervals, and then you have to write new applications for more money, and you have to show us different kinds of plans, and so it's relentless. But that's sort of the nonprofit world these days. It's, in a sense, it's more and more like running a business, because you're constantly marketing what you can do, and you're trying to convince a third party to pay for you to provide services to somebody else who is not paying for it. And it's convincing the third party that legal services add value to a community, when I don't think this is any different now than it's ever been. The tendency is to see lawyers as troublemakers rather than as added value. So it's, I remember Bill Ide talking about marketing and, the public education aspects of convincing people that legal services was worth supporting early on in the formation of legal services. It's still important now. We're still engaged in public education and communications every day, talking to people about the real important individual personal cases, personal rescues, and personal achievements and steps out of poverty that we're trying to do on a daily basis, a real individual personal basis, and on community kinds of bases.
If you were to kind of look at sort of either continuities or changes over the 28 years that you've been, what are some of the things you'd point to?
In a sense, their continuities and changes are tied together, because it's the more things change, the more they stay the same. There's the political winds just blow hot and cold. There's the progressive periods and the regressive periods, the conservative periods. There's support for legal services at some times and in some quarters, and then not in other times and other quarters. I think we are in a posture now where we are definitely seen as an important part of the legal profession, as part of the establishment in a sense. And there's no question now that leadership of the state bar politically has to support legal services in order to be in the leadership. It's not necessarily their top agenda item, but I think they have to be supportive of legal services. And the state bar, that's not an issue anymore. I think we are seen as a player in public policy debates among state agencies, and that's a nice place to be. They don't always do what we think they ought to do, but I think we have a place at the table, and that's a nice place to be.
It's interesting. I mean, at some level, the evolution of legal services has precisely paralleled your own evolution, from somebody in their 20s to someone in their 50s.
You gave it away. You can do the math, right?
But I'd be curious, you start off as this legal services, in some ways being anti-establishment, and now you're talking about being part of the establishment. Maybe you could kind of talk about that transformation over 28 years.
I think it's part of learning how to be an effective advocate. And there are different ways to do that depending on who your audience is, who your target is, what your issue is. And sometimes you have to approach it from the outside, and you have to just stake your territory and assert your case. Never mind whether people are going to like you or not. That's just what you have to do, because that's what the right position is. On the other hand, there are some arguments or some battles that you win better, more easily from the inside. I spend a lot of time now in meetings of one sort or another, commissions of one sort or another, watching how people are effective or not effective, and continually trying to learn how I can be more effective. There still is an issue about women in various kinds of settings, even among the bar. You know, how are women effective? How can we be effective in among? I'm at this point the only. Well, there's another woman just been elected to the executive committee of the state bar. You know, but there are issues about, is my voice heard? And is that because I'm a woman, or is it because I'm a legal services lawyer? What are people thinking about that? And I'm constantly trying to figure out how to do that more effectively. And is this a battle you can win by being in a meeting and talking and persuading, and how do you do that? Or is it a battle that you have to take to another forum? So I think it's an increasing level of sophistication, an increasing toolkit, to use a phrase people like to use now. You can pick different things out of your bag.
If you were to look back and sort of pinpoint some of the signal accomplishments, but also some of the areas where maybe legal services hasn't accomplished as much as you might have hoped once upon a time, or others might have hoped up, you know, what kinds of things we need to get.
Oh, I think Georgia Legal Services has done so much. We've done, I mean, the prison system is just so different. Still, clearly, big problems, but so different than it was in the early 70s. We had major impacts on voting rights. We had major impacts on the mental health system in the state. We've had impacts on for people with children with disabilities. We've had major impacts in consumer law, although there's been a lot of retrenchment in consumer law, partly because of the successes that we've had. I think we have opened people's eyes to the lives of people in poverty. A lot of our volunteer lawyers now get it, understand what life is like for people in poverty. And that's an ongoing effort to educate people about what it's like to be poor, and that it's not just laziness or some inherent defect in your will to work. On the other hand, there still is real entrenched poverty. There still is real disparities in income distribution and wealth distribution. We are spending significant resources now on community economic development activities, trying to help grassroots organizations solve community problems with job training programs, or trying to build affordable housing through sweat equity programs, land preservation, black land preservation efforts, things of that nature. But in rural Georgia, there are entrenched areas of poverty that lawyers in the legal system can't fix except in kind of a peripheral way, and that's a frustration for me. There's still that part of me that wants to fix this poverty thing from 30 years ago. And while I think we have done a tremendous amount to make the world a better place for poor people in Georgia, there's still a lot of poor people in Georgia. So, and I can't fix that.
Okay,
I got a question, actually, if I might, which is, has the events of 9/11 and succeeding fallout impacted your work at all?
Not that we have really been able.
Talk to Cliff.
Not that we've really been able to tell. We thought initially that, particularly in the counties that we serve that are south of Atlanta, near the airport, the people who come into Atlanta who work in the hospitality industry, there were a few cases early on where people were, getting laid off and that sort of thing. But we haven't seen the impact that I thought we would have. In fact, I was down in Savannah several months ago, but after 9/11,